friends. Hello. My name is Alina Shevtsova, New York immigration attorney. Today we're going to have live discussing the most interesting recent immigration news. Welcome to my show. We're going to be talking about arrest of a judge by the FBI. We're also going to talk about the fact that SEVIS records of students have been reinstated, those records that were terminated first by ICE. And of course, in the end, I'm going to be answering your guys' questions. So thank you very much for joining. If this is your first time here, welcome. Say hello. Let me know where you're watching from. And of course, type up your questions so that we will be able to discuss them in the end. If you're watching me on TikTok, welcome. Don't forget to send your hearts. And of course, type up your questions. If you're watching on YouTube, please share this show. And if you're watching on Facebook, send your likes and stars. I hope you all had a wonderful week, and we're going to start. Very interesting information came from Milwaukee. County Circuit Court Judge Hannah Dugan, if I pronounce it correctly, charged with 2 felonies in ICE case. This is crazy. I have to tell you, this is the first time in 17 years that I've been a licensed attorney in the United States that I've seen anything like that. What happened is that on April 18th, if I'm not mistaken, this judge had an immigrant appeared in front of her in connection with some domestic violence charges, from what I understand. And during the course of that day, the judge was informed that ICE agents were in the courthouse trying to pick this man up. And the judge did not want this to happen. She was upset that the enforcement was happening in her courtroom, or would happen in her courtroom. And from what I understand, at some point, the judge directed, according to the mass media, I don't know what happened, the judge directed the immigrant to leave the courtroom through her chambers. And I guess there is some second door that would lead a person out of the courthouse. So the agents got very upset about this, and they chased the immigrant nevertheless, and the immigrant got arrested outside of the courthouse. But about a week later, the judge was picked up now herself on federal charges, 2 federal charges, 2 felonies, and from what I read, she may be facing 6 years in jail, even though nonviolent offenders usually do not do time. But this is a very serious matter, because I'm going to tell you that I've never seen anything like that. From what I understand, the judges in their courtroom have some authority as to who they may and may not allow in the courtroom, right? And the agents had only administrative warrant, not a judicial warrant to arrest the man. So that's going to be a very interesting case. I want to see what the rest of the judges are going to say, right, about this whole situation. And the judges appeared in court already. This judge appeared in court already in connection with her own charges. And frankly speaking, from what I've known about judiciary, I thought that before a judge is arrested, FBI has to have a warrant signed, and I believe they have to be consent by judiciary, some kind of a committee on judiciary, but I may be wrong. So we're going to see how this whole case is going to resolve, what's going to happen, but that's definitely going to have a chilling effect, not only on public, but on the judges also, as you can imagine, right? Well, on a good note, we do have some positive news related to the fact that students' SEVIS records are being reinstated. Within the past couple of weeks, we received reports and reports of students losing their status in the United States because their SEVIS records were terminated. And some of the students were so close to their graduation, they would have lost their opportunity to get the diploma. And in many cases, the termination was coming from the fact that a student had some sort of a minor charges against them. And very often those charges, criminal charges, resolved in students' favor, meaning that the person was found innocent or the charges were dismissed. Nevertheless, ICE picked up on those charges and started terminating the students' records. And guess what? There was a class action lawsuit filed, and as a result, ICE, at least temporarily, reversed their policy, and students are being reinstated, which I am believing great news for many students, as again, especially for those who are PhD students and students who are close to their graduation. Now they possibly will be able to graduate. However, you need to know that this is not the end of the story, okay? According to the statement published in the news, I stated that they will first publish the official policy as to how they're going to go about terminating SEVIS records, and then they will start the process again. So this is not the end, it's just the beginning. But hopefully at least some people will be able to benefit from this temporary policy change, at least for a little bit. And now, guys, if you have questions, I'll be very happy to answer them. Let's go see what's happening. Thank you guys very much for joining. And let's start. Hi, Evgeny. In July of 2017, my brother filed an I-130 petition F4 category, sibling of a US citizen. I'm 42 and I have my own family, currently in the United States with a pending asylum case, waiting for the interview. All right. And why is this line is not moving at all? And when do you think the visa will be available? Right, Evgeny, if I'm not mistaken, people in F4 category must wait for their visas for at least 15 years currently, right? And this visibility line is changing from month to month. But you're right, it's very, very slow. Sometimes it moves up only 3 weeks at a time. Why? Well, because it's probably the lowest priority line, and there are so many petitions in that line that the line is basically overbooked years and years in advance. However, you need to know that if you have only asylum pending status, it will not allow you to file for adjustment of status at the time when that visa will become available, and most likely you still will have to go through consular route to benefit from that F4 petition. All right, that's what you need to know about that F4 category. All right, let's see. Hi, Ahmed. I sent EED renewal through pending VAWA. My current EED card category is C09. I received receipt notice, but class category was C31. Does this mean I'm eligible for automatically extension of 450 days? Well, if I'm not mistaken, the automatic extension is 540 days, and C9 is definitely on the list of those automatic extensions. C31, however, is for those whose VAWA is already approved. You cannot receive C31 category if your VAWA is not approved. So maybe you just received that C31, but you're saying that you have a receipt saying that it was C31. That's unusual because typically USCIS is not going to put C31 by themselves. They have to put C09, especially knowing that C31 can be only assigned to you if VAWA is approved. So I would say, why don't you do some investigation with your attorney as to what happened, okay? And if there is a mistake, then you guys have to reach out to USCIS to correct it, because you do not want to wait for that for the decision for months and months just to find out that there was a mistake made and they will deny your application. All right. C31 is only for those whose VAWA is already approved. Okay. Now, you guys on TikTok, thank you for your patience. Let's see what questions you've got. Hello, everyone. I hope you have a very nice day. Thank you, Greg, for your gift. Thank you guys very much for your hearts. If you're watching me on TikTok, you can tap the screen and I will receive hearts. Yeah, that's very cute. Right. Thank you guys for your hearts. If you have questions on TikTok related to the United States immigration, please let me know. Don't be shy. Hi, Cecile. For cancellation of removal, Is it safe to go to the immigration court in Newark? Individual hearing is coming up in a couple of months, I guess. Is it safe? Well, first of all, you need to know that you have no choice but to appear, all right? But I understand your question relates to expectations as to what's going to happen, right? If a person doesn't have any arrests, outstanding tickets sometimes, even tickets may present an issue, you shouldn't be worrying about being arrested in that courthouse, okay? Even if you lose your case. Why? Because if you lose your case, you reserve your appeal rights, and for 30 days, the decision of the judge doesn't get into effect. And once you file that appeal, the case is frozen pending the appeal results. That's how it works. So I think you should be all right, unless I do not know something. If you do have any reason for concern, such as previous deportation orders at some point, criminal charges, then of course consult with your attorney. But remember, you don't have a choice whether or not to appear for an individual hearing. If you guys don't appear for an individual hearing, what's going to happen? They're going to order you deported, and then you're for sure going to be picked up. Okay? Hi, Old Wolf 07. My I-130 is approved. Will they approve the motion for determination? I guess motion for termination? Maybe not. I-130 by itself approved is not enough sometimes, especially at this time, for the court to approve your request to terminate the proceedings. I would say it's strictly going to depend on the judge. They may ask you to file I-45 with the court instead. You just need to be ready for that, okay? Just need to be ready for that. Hi, Gentle Wise Entertainment. Interesting name. Thank you for the gift. Hi, Ron. A Palestinian who has been over a year in the United States. Can we apply for asylum considering the war now? The war by itself does not give you any ground to file for asylum in the United States. This is true for Ukrainians, for example. Just because there is a war in your country, it's not a ground for asylum. However, if there is something else involved, something where you can argue that you're going to be persecuted in your home country based on nationality, religion, race, membership in a particular social group or political opinion, then you may file for asylum. In certain situations, you may ask the government to restore your 1-year deadline, all right, depending on your personal circumstances, change of country conditions, things like that. So sometimes it's possible to receive asylum even if you didn't file for asylum within that 1-year statutory deadline. Okay. All right. Hi, Chris. If you are at the I-601A process and you win the diversity lottery program, is it easier for the paperwork? No, it's really not easier, unfortunately. If you filed for I-601A, it means you cannot adjust in the United States. All right. So you're welcome, Aaron. So what happens with that I-601A? It waives preemptively bar of foreign lawful presence, all right? But to get to the I-601A stage, it means that the petition was filed for you already. And diversity lottery is just going to be another petition. It doesn't boost your I-601A application, all right? Hi, Justin. It's been 1 year since I got out of removal, and the judge told me and my lawyer on the record he would approve the case. 1 year later, the case is still pending on EOIR website. Adjustment of status. My lawyer refused to reach out, saying she's waiting for them to reach out. What can I do? I'm scared. Well, the case is still pending. It's good news. It means you're not deported. All right, that's number one. Now, the lawyer may be reluctant to reach out because sometimes lawyers believe, and sometimes it's true, that if you're going to be bothering the judge, they will deny your case. Listen, we're all people here, and I know it shouldn't happen this way, but it may. But I say this, if the judge waited for that long, a gentle reminder wouldn't hurt, I would say. All right, I would start with the judge's clerk, just reminding that case has been pending for a while, but remember that your attorney has to copy prosecutor on all communications with the court. Or you say for cancellation of removal? Cancellation of removal case, right, Cecil? Yes, we discussed that. Yeah. All right, so let me see what else we have. All right. Let's see, guys, from TikTok. Hi, John. Oh, as it should be, violated the law. Well, I don't know about that. I think the federal judge is going to deal with that. Because again, you see, ICE can access public places. The question will be, would they regard that courtroom as a public place or private place? I do not know. I really do not know. I think we need to talk about this because let's say ICE would like to enter school. Without superintendent's consent, they will not be able to do that unless they have a judicial warrant or there are some very special circumstances. And another thing is this, why ICE just didn't wait for that person outside of the courthouse? I do not know. There are too many questions, and I think the federal judge will have to answer those questions, right? How long are the green cards taking for asylees? Hi, Juan and Eve. Well, currently, USCIS paused processing of green cards for asylees and refugees. So typically, you would receive a green card after you complied with all the requirements, meaning that you resided in the United States for at least 1 year physically, and you don't have any disqualifying factors. I would say the processing time would be anywhere from 6 months to 8 months. Last year, we received the green card very quickly, like 4 months it took us. But now they stopped the processing of the green cards for people who want asylum. So it may take much longer, all right? Until they, I guess, resume the process. All right. All right, let's see. Thank you guys for sharing this live. Thank you very much. Is it truth that green cards for Asylees are paused? Yes, it's the truth. Well, at least that's the announcement we received, right? They stated that they will be pausing processing of green cards. But if you're watching my lives regularly, I also told you that I guarantee you that we're going to see some approvals still happening. You mentioned here that you received an RFE. It means that your case is being processed. The question will be, which I think we'll never get the real answer to this question, for which asylees and refugees specifically they paused the process and how they were selecting those people. I don't think we'll ever get the answer. So when we receive a general announcement like that, it usually means that the government is going to be selective with people that they will be allowing to move forward on some interesting basis that is unknown. I also, in that video, and now I will repeat it again, I'm going to share the following. If the country conditions in your country changed so that you no longer qualify for asylum or refugee status, instead of that approval for the green card, you very well may receive what? A notice of intent to terminate your status. You have to understand that, all right? But only let's say if the country conditions changed, or if the government finds out that you received your status fraudulently, right? All right. Hi, Abdul. There is any processing of work permit for asylum seekers if you are not on the parole program as of now. If you're an asylum seeker, I'm not aware of any cancellations in the policy that you're entitled to a work permit provided conditions were met. 180 days passed, right? Since your application was accepted. So I think those people should be fine at least, right? But let's see if we have more questions. Can I apply for Europe work permit? Hi, hello, boss. You probably can, but I cannot help you with that. I help people only with United States immigration laws. All right. Another attempt to break Constitution. Yeah, I know. Well, we'll see what's going to happen with all of this. New approach to the judiciary where judges are being threatened with impeachment, with firing, with criminal charges now. I personally have never seen anything like that. And it's very, very disturbing because, if you ever had to take that N400 test, civic test, there is a question there. What makes the United States to balance powers, right? And it's a separation of powers, system of check and balances. No government branch has to can become too powerful, because then democracy is going to collapse. We have system of checks and balances. Executive branch wants to do something, you can file a lawsuit, the judges are going to decide whether or not they can do it. Congress makes the laws. If all the powers are in one hands, then it's not a democracy anymore. That's what I was taught. You can share your thoughts, what you believe. What do you think is the right course of action here? Please don't be shy. We have an open discussion here. Now, let's see if we have more questions. Please let me know. All right. I'm going to go to the end. The misbehaving judges have betrayed the democracy by their behavior. I don't think they misbehaved. None of them actually misbehaved. They were following what they believed the law, and there were precedents in the past about that. So I don't think that if you do not like judges' decision, you should threaten them with impeachment. There is a procedure to go about that. It's called an appeal. That's exactly what the Chief Justice of the United States Supreme Court stated in their statement. All right, that's what they stated. Don't break the law, and you will not be arrested. All right, so you know that there is a presumption of innocence. Sometimes you can be arrested even if you didn't really break the law. Just because the person was charged doesn't mean that they're guilty. All right, and that's another very important principle of the United States justice system. And of course, we're going to see again how it's all going to play out, but I strongly believe that in the end, the principles that were placed in the Constitution and were developed throughout centuries are going to prevail, no matter what some people believe they can and cannot do. Thank you very much, guys, for your nice words. Let's see if you have more immigration questions. Hi, peace on earth. Does a 212H waiver granted by USCIS cover both inadmissibility and deportability when adjusting status if the crime covers both grounds, even though it says inadmissibility? Right, so once you have been granted that waiver, you should be good to go with your future applications, all right, provided that you did not break the law again and you need another waiver, because usually you can file only one waiver, all right? All right. Hi, Juan. They sent me the RFE 3 days before the announcement about the pause was. Okay, the RFE was for criminal record, but I don't have any. All right, so we're going to see how it's all going to go. Just follow your case in the case status, even though I feel like it's useless for the most part. But hopefully, don't forget to join us back and share with us good news if it's going to be that your case gets approved, because we all would like to know if they are actually processing cases, okay? Because I think they would process some cases. We just do not know which cases exactly, all right? So let's see if we have more interesting questions. And guys, don't forget to follow and subscribe if you haven't, so that we're going to meet again to discuss some interesting immigration news. Trust me, each week we have tons of news, tons of interesting stuff, you know. Hi, Cecile. Can you self-deport or voluntarily depart if your cancellation or removal case denied? Well, you can always self-deport, but it also will mean that there is an order of deportation against you and there is a 10-year bar. Because once that order of deportation is issued, you're going to have 10-year bar. Thank you, Peace on Earth, for your gift. Thank you very much. So I'm going to answer your question next. So there is a difference between self-deportation and voluntarily departure. Voluntarily departure is actually a relief that you have to ask the court for, and the court has to grant it. There is a pre-conclusion voluntarily departure and post-conclusion voluntarily departure. So I guess depending on where in the process you will feel that the judge is going to be denying your case, that will be the time for you and your attorney to ask for that VD if that's what you choose. I'm not in favor of VDs unless you're absolutely sure you're going to depart the United States. Why? Because if the judge grants voluntarily departure and you fail to depart, the consequences are horrifying. That order of VD turns into the order of deportation, and for 10 years you will be barred from asking for any type of relief. So please think 300 times before you're going to ask for VD unless you're absolutely sure you would like to depart the United States. Okay? That's what you should keep in mind. Hi, Peace on Earth. I got I-601 waiver approved for a crime of moral turpitude that is also deportable and 3 misdemeanors that are dismissed, even though I got the waiver. If I apply for N400 and get denied for good moral character, can USA issue NTI for the deportation crime? Not for the ones that you were granted a waiver for, okay? But those misdemeanors that were dismissed, I do not know what happened with those. This is would be my general advice. If you guys ever had any criminal convictions, criminal charges that were dismissed, even not dismissals, not every dismissal is equal. Some case dismissed for failure to prosecute. Some cases are dismissed for, like in New York, we have this ACOD, adjudication and contemplation of dismissal, where a person still receives some sort of a punishment, like anger management classes. So what I would do if I were you, I would wait for 5 years to pass since the time the cases were closed, and then file for citizenship. If you were filing for citizenship with these same facts when the Biden administration was in office, I would say you wouldn't have any issues. Now, they may hop on your case and start trying to accuse you of being guilty of the crimes, even if the cases were dismissed. How would they do it? Well, they ask you what happened. And if they see that there was some sort of a punishment assigned, like a fine or anger management classes, or if you say, well, I actually did it, but then we reconciled in the case of domestic violence, right? Then you may still found to be guilty and lack of good moral character and so on and so forth. So what I would do if I were you, I would take your certificate of dispositions for everything that you have and show them to your immigration lawyer, because I think you had one or have one, right? Somebody who you worked with when you filed for those waivers and previous applications, or you can choose a new attorney. It's up to you. And then that person has to advise you whether it's worth it for you in your situation to go for the citizenship now or not. I would say, if I had to guess, that you will be fine. But prior to me saying that, I would want to check every single possibility that may happen in your particular case based on your particular facts and your paperwork. That's how I would do that, okay? So dismissed usually means you're fine. The government may be curious why you had 3 misdemeanors. Are you like not respecting the law? Are they all occurred on the same day? What happened with those charges? So just double and triple check with an attorney, and then I think you should be absolutely fine. All right? That would be my guess. But again, this is not legal advice here because we're publicly discussing issues. This is more like a tip as to how to approach your situation. Take the certificates of disposition, take your previous immigration paperwork, show it to your attorney, and then you're going to have good understanding as to how to approach the situation without fear of your application and 400 resulting in deportation instead. Another thing, even if the government will try to deport you, you discuss this with an attorney. Would you have a way out? Sometimes if you have a safety net, you don't need to worry about it, okay? All right. Let's see. All right. Thank God. All right. I have a lot of people who believe that the judge should have been arrested. Well, thanks for watching my show. I just don't know why you're doing it because this is for immigrants. But hey, you're welcome. As long as you're not offensive, you can please share your thoughts. All right? Please share your thoughts. Remember, just being respectful. I guess there are people who believe that judges should be somehow, held in contempt or something. I don't know. I have a tremendous respect for judges. In the United States, judgeship is more comes as a service rather than some position of where you can get like rich, because judges have to work so hard, and believe it or not, the compensation is below of what they're supposed to um, be compensated for their very hard work. And it's hard to find judges, believe it or not, because not everybody in a law profession would want to give up, a possibility of higher income for this service position. So I don't know, guys. All this is like make me super uncomfortable when I read that the judges are being attacked, threatened, and so on. Independent judges are extremely important for the system of checks and balances, and everybody, including the public, have to understand that and have to protect the judges. Again, there are special ways to go about if you believe the judge violated rules, if the judge violated ethical rules, but it's not threatening them with criminal charges just because you didn't like the way the judge ruled about something. All right? That's how it goes. All right. Let's see. Can you explain how a judge isn't required to act on administrative warrants? Oh, yeah, I did it at the beginning, actually, of this video. Administrative warrant allows the ICE to pick somebody up in public places if they enter a place that becomes that enjoys certain privacy, and the person who has custody of that place denies access to ICE, to law enforcement, then to pierce that denial or consent, ICE would have to have a judicial warrant. And that's what the judge told them too. They said that you have to have a judicial warrant to complete this enforcement in the courtroom. That's what I understood. I may be wrong, but when I read different articles, that's what I understood. So that's what happened. Now there are accounts of the judge actively helping the person to escape the enforcement. That I think is different. And again, I did not observe any of that. And whoever observed would have to testify as to what they saw and what the judge did and how it all went about. Remember that the person appeared in the judge's courtroom because I guess they were summoned to be there. So I don't know. I don't think the situation is that one-sided here. I have to be honest. All right. I think that we're going to see some interesting resolutions to the situation. Okay. Hi, Cheryl. My fiance went for interview, and after 1 week, the case was back to National Visa Center. What can I do? I don't know why it was back on the National Visa Center. National Visa Center deals with cases that are going to go through consular processing. So, oh, you mean that they went for the interview at the consulate and the case was back? Well, there may be multiple reasons for that sometimes, but it will not be back to the NVC. It will be back eventually with USCIS. Consul believes that fiance petition is not should not have been approved, and then they will kick case back, or I-130 petition should not have been approved. They will kick case back to USCIS, and you're going to receive notice of intent to revoke. But that's just my guess. Maybe something absolutely different is happening in your case, right? Was there any notice of administrative processing? I just do not know the details, to be honest. Hi, Marat. My wife got green card 42B and mine's still pending. Made online InfoPass appointment after 45 days. When do you think they will call me? They usually call within 30 to 60 days. I think that's what they say when you make those appointments, and they usually do call. You just have to be ready with to pick up that phone call, right? Can someone with advanced parole travel outside the country? Yes, that's why they receive advanced parole. Advanced parole, you don't need it unless you're going to undertake international travel, right? Hi, Nature Maps. Is it safe to file for a U visa? Yes, generally speaking, it should be safe. Depending on your background, check with an attorney. But absolutely, guys, if you're a victim of a crime in the United States and the law enforcement signs that U visa certification, please file for the U visa. It takes forever to receive an approval, like 5 to 7 years. But you will be able to get a work permit if your case has merit, and then you will be able to wait for that U visa status. All right. All right. Stefan, is the judge removed once the felony happens to a judge? Well, if the judge is convicted, I can imagine that they will be, yes, they will probably resign from the bench. And perhaps the judge is going to take a leave of absence now. I do not know, but we'll see. Some of the stuff I can imagine will not be public. All right. Can someone with advanced parole travel? Yes. Okay. Judge can be guilty as anybody else. Well, they can, but in this particular situation, as I said, it's a very interesting question because I think the judge has authority over the courtroom they're sitting in, because they presiding over the courtroom and they control the order. The judge may hold certain actors in the courtroom in contempt of the court because they may order a certain behavior from visitors of the courtroom. So I do not know, guys. It's not that simple as you may think. It's. I think that again, I think federal court will have to answer some very interesting questions here. Hi, Masroor. If VAWA gets rejected and someone gets married to another person, how does it affect the person's file of a case? I guess it will depend on why VAWA was not approved. If the government believes that you entered in a fraudulent marriage, marrying someone else and that someone else filing for you is not going to help you, unfortunately, okay? Hi, Diana. Thank you very much for your channel. My family immigration history was during the Great Potato Famine in Ireland, very different times. Yes, it's true. We throughout the United States history, we see waves of immigrants trying to escape various disasters and wars, and these times are no different. Tons of immigrants are drawn to the United States as a safe harbor, and maybe your family shared some stories in the United States, there have always been times where certain immigrants were regarded as not wanted, right? There was a time when Italians were not wanted or Irish people were not wanted. Now we see people from Central South America being rejected, right? It's like we don't want them. That's some people here would argue. It's always like that. There is always resistance. There were some darker times in the history of the United States immigration as well. For example, camps for Japanese people, right, during certain events, or listen, the examples are endless. What's good about the United States is eventually system of checks and balances evens things out, and today the United States is the best country in the world no matter what. It's just the best what we've got, and that's why we really have to guard the democracy and equality, and really appreciate what we have. Nobody said it's going to be easy, right? But that's all we've got. That's all we've got. All right. See what else we have. It took 1 week to arrest her. Well, they can't just arrest a judge, as I said. There have to be certain procedures observed. So I think that's what was happening. Somebody would have to sign a warrant, and certain permissions would have to be obtained prior to arresting a judge. Well, guys, listen, thank you very much for joining tonight. Thank you for being respectful, all right? Again, like, share the stream. Please join back next week, ask your questions. And I hope you're all going to be safe and healthy. And I hope to see you all very soon.